Hi, everyone. It's Neil here from Toronto Condos, and welcome to our Toronto Condos podcast. Today, I'm very excited to have a guest here with us. He's an experienced real estate lawyer, Chris Martin. I'm going to hand it over to Chris, and Chris is going to do a quick little intro of himself. But what I wanted to mention about Chris is I've known Chris for some time. Chris has actually helped me personally close on an investment property. He's helped out some family members as well as clients. So I really trust Chris, and his level of knowledge is very high. So we feel very comfortable when we're working with different clients to refer them over to Chris. So Chris, what we'll do without further ado, I'll flip it over to you and maybe just give viewers just a little bit of background about like who you are.
Yeah, for sure. Thanks, Neil. So my name again is Chris Martin. The firm that I work for is Rose Law. I'm the only lawyer here, though. We primarily practice residential real estate and commercial. So that's kind of our area of expertise and what we focus most on all of our efforts. I've been doing it since about 2012. Again, mostly focused on residential, but a lot of pre-construction condos, pre-construction homes, dealing with both people buying for principal residence and investment purposes as well.
Yeah. Awesome. Sounds good, Chris. So let's get right into it. So for viewers, for the Toronto Condos podcast, they're interested in looking at pre-construction condos, essentially.
Right.
And with it, as you know, come a lot of questions. So one of the questions that we get is, once somebody's bought, say, a pre-construction condo, or they're looking at buying a pre-construction condo, why is it important to have a real estate lawyer knowledgeable in pre-construction review the actual agreement?
For sure. Well, the main thing is if anyone's bought a pre-construction and they've seen the amount of paperwork that's involved in it with the agreement of purchase sale, which is usually 80 plus pages, and then the condominium disclosure documents, again, probably another 100 pages. There's a lot of documents or a lot of information to review. The kind of one main thing is when people are buying the pre-construction, unlike a resale property, is you have something called the 10-day cooling off period. And that 10-day period that allows the buyers to have the contract reviewed, try to negotiate any kind of changes, but it just gives them time to secure financing, and gives them an option that if within that 10-day period, if they see something they don't like or they're uncomfortable, they change their mind, they're able to, it's called rescind the agreement, or basically back out of the agreement with no penalty, and they get any initial deposit that was paid back without any deductions. So from what I see, the importance of the pre-construction contract is a lot different than the resale in the sense of, and the main things are, one is the closing adjustments, which are usually listed in a schedule to the agreements, but there are additional costs that the builder is able to charge you on the final closing. And generally they're not insignificant amounts. They can be, anywhere, I've seen them as high as $20,000, $30,000 of additional costs. So that's something you want the lawyer to review, point out those costs to you, and try to negotiate with the builder to either, remove some of them, cap some of them, so you have some cost certainty when you're closing. I'm sure we'll talk more about that in a sec, about the closing adjustments. The other reason you want to have it reviewed as well is pre-construction condos have, all pre-construction condos have a two-stage closing. They have this occupancy closing, it's called, where the unit is available for someone to move into, but the title of the property or the final closing can't occur yet because the rest of the building's not done and the condominium hasn't been legally registered yet. And so they have this two-stage closing, which for most people, if you've bought a resale property, that would never happen, or a resale condo, that would never happen. So those are kind of the two main things you're looking out for. The other things, again, with a pre-construction condo, you want to go over any warranty protections, which is through a company called Terion. and just little things, to make sure that people understand what their rights and obligations are, and what's required, what the builder expects of them, and vice versa as well.
Yeah, no, it's a great point, Chris. And you've touched on this, especially with the two-stage closing. That's one of the biggest questions I get from people. They're like, "What's interim occupancy period?"
Right.
Yeah, really, really important point to know. So that was a great explanation. So when you're actually looking at the agreement, and I know you touched on this a little bit, but when you're actually reading the pages and going through the actual agreement, what are the specific things that you're looking out for when you're reading it?
For sure. Well, so the first thing we like to determine from the outset is what's what's your intention to purchase the property? Are you buying for investment purposes, or are you buying for principal residence? The main reason for that is because all new home contracts, or new construction or new condos, have HST attached to the purchase price, which is different than a resale where HST is not applicable. Now, HST, when they give you the purchase price, is included in the final price they give you, but what's something they don't do very your principal residence, then there's an HST refund that you basically have to pay to the builder on the final closing, and then apply for it back directly from the government yourself or from the CRA yourself. So the builder's contracts by default assume that you're buying for principal residence purposes, either you or an immediate family member, and they assume that you can assign this refund of the HST back to them. So I get a lot of questions, and people think they're missing out on a refund or missing out on some kind of rebate that the builder's taking from them, and that's not the case. What it is the builder is actually giving you the benefit of saying, instead of making you pay that refund up to them up front, they'll just let you to sign it to them, so that you don't have to chase the CRA for the money after closing. But the catch with that is that it can only be if it's your principal residence for you or an immediate family member. And so what happens is that if it's not, so if you're renting it out, for example, or an investment, you don't qualify to assign the rebate or refund. You have to pay that money upfront to the builder on closing, which is typically about $24,000. And then you can apply for that rate or refund directly from the CRA. The conditions of that are that you have to have a 1-year lease in place, and you cannot sell the property for 1 year from final closing. So that's kind of the first step you want to look at, so people aren't getting surprised. And I see it quite a bit where people don't have contracts reviewed, and they come in for the closings with us, and they advise us it's a rental, and then we have to advise them, okay, so you owe an extra $24,000 up front on the final closing. And that's sometimes quite a big shock to people, because you can't roll that money into a mortgage. And so it's basically just, that's the major thing I think we first look at. The second thing is like you said, is explaining the occupancy versus the final closing. So the occupancy has, and I've seen it on the internet described as, there's occupancy fees, and they call it a phantom mortgage, which, because you're occupying the property and not a legal owner of the property, your mortgage doesn't kick in yet. So you pay something called occupancy fees, or basically you pay rent to rent the property back from the builder until the property is fully complete and all the common areas are done and the final closing can occur. Occupancy can be, there is no usually set time period. It can be anywhere from 6 months to 2 years. Typically contracts have a maximum length of time that it can be no longer than 24 months. I typically see 8 to 10 months is what the occupancy time frame is what I normally see. And in that period, you're paying these occupancy fees, which are made up of 3 components. You're paying estimated property taxes, you're paying on a monthly basis, you're paying estimated condo fees, and you're paying interest on the unpaid purchase price, or that they call the deferred purchase price. So for example, if you're buying a property for $400,000 and you only have $200,000 as a down down payment and you're financing 200,000, you would pay interest as part of this occupancy fee on the 200,000. So the way they calculate that interest, it's based on the Bank of Canada's 1-year conventional mortgage rate. So right now, I believe you're paying interest on it's 3.64%. So again, not an insignificant amount of money. If you think that on just 200,000, and I can't do math in my head, but just on 200,000, you're looking at that works out to being interest of about $606 a month. So your occupancy fees are generally anywhere from, depending on the purchase price, but they're over $1,000, over $1,200 for sure. And the other big thing is that you don't get credited with this amount against the purchase price. So it's truly you're paying rent to have either yourself or someone else live in the property. For people that are buying for principal residence, it's generally not a huge issue. It's maybe a timing issue when you're selling your current house or, giving notice of your current lease that you want to move in, but you're basically paying rent to live in a property. You're just not getting the benefit of creating equity in the property at that time or paying down a mortgage. For investment purposes, and this is one of the things you want to do during the 10-day window, you want to get the builder's approval or consent in writing that you can rent the property out during the rental period or the occupancy period. This way you can have a tenant then cover your occupancy fees so you're not paying any out-of-pocket expenses yourself. But you can only do this during the 10-day window generally. I have seen it where builders will allow you after the fact to consent to it, but they don't have to. The agreement doesn't provide that they're required to give you the consent. And so that's another reason why it's important to have the agreement reviewed in the 10 days. I will qualify that that those three components of the occupancy fees, the taxes, the condo fees, and the deferred interest, or the deferred interest on the deferred purchase price, you can, if you're able to, on occupancy closing, to pay your full balance of purchase price. And the only way you can do that is that if you don't need mortgage or secured line of credit for financing, if you're able to pay that up on the occupancy, that money is held in trust by the builder's lawyer, so it's protected. But you can not pay the interest component on the balance due on closing, which again just saves you. So then your component is only made up of the monthly property taxes and the monthly condo fees. So it's a little bit of savings, but again, most people can't do that because they require financing.
Yeah, that's a good pro tip, Chris. And just to kind of maybe come back to that, like you said, the profile perhaps of that person is much smaller because
Right.
most people can't afford it. But that's interesting how you'd mentioned. So, and correct me if I'm wrong, if you have, say, cash savings available, it can't be through a mortgage or secure line of credit. If you have that available during the 10-day cool-off period, you can notify the builder and basically pay that. It's held in trust. And then once you hit the interim occupancy stage, they do not charge you the interest portion on your future mortgage amount. Yeah.
Yeah. So you wouldn't have to actually pay it till the occupancy stage. So you're not paying it when you first sign. I guess you could have it for investors, especially if you had a secured line of credit against your principal residence. You could use money to draw down on that to purchase the investment property. That's possible as well. It's sometimes beneficial because with investment properties, you can claim or deduct the interest on those payments against any profits or income in the future. So that's a positive for investors. But yeah, and then the important point you brought up is that you have to make this election during the 10-day period. If you don't, again, the builder can always agree to it, but from what I see, if you don't make the election, they generally don't allow you to change that election or change your mind after the fact. And even if they do, they usually charge you some kind of legal or admin fee, which is typically around $500 to do that.
That's a great point, Chris. And I guess just lastly on this point is, like you said, you have to elect during the 10-day cool-off period. And just so it's clear for viewers, if they have a secure line of credit, say on their principal residence on their home, can they use essentially those funds towards?
Yes.
Yeah, they can. Perfect.
Yeah, they definitely can. Yeah, they definitely can. That's what I see a lot of investors doing, because it's a way, and then it's a way to just avoid that interest component on the occupancy fees, and which can be, again, depending on the purchase price, can be quite a lot of money.
Right, exactly. And again, that, say, leveraged funds, to your point, would be paid at occupancy, not during the 10-day cool-off period.
Right. Exactly. Yeah. So, and like you mentioned too before, it's held in trust by the builder's lawyer. So there's not an issue of you worrying that money is going to disappear or be taken or anything like that. The agreement requires the money to be held by the builder's lawyer, and the Condominium Act also requires all money received on a pre-construction condo purchase to be held in trust by the builder's lawyer. Only way they're able to ever release it before closing is if they get an insurance policy for it. So either way, you're protected if they get an insurance policy and someone misappropriates the funds, or I guess if the builder went bankrupt before the closing, that insurance policy would cover the return of your deposit.
Yeah, no, again, great pro tip. And just to kind of maybe, talk on that a little bit, because this is great content. Say an investor does that, they provide, they use their secure line of credit, they provide the full amount, they pay it during occupancy so that they're avoiding the interest payments then during the interim occupancy. And that doesn't then prevent, say, an investor, correct me if I'm wrong, come final closing, if they go out then and get a mortgage from, say, RBC at 80% loan to value, they can then pay back those secured funds back to their home, principal residence.
For sure. Yeah, definitely. Yeah, definitely they can. For sure, they can do that.
That's awesome.
No, there's definitely a benefit to do that. So, again, if you're not able to rent the property out during the occupancy period, then that's one. Or if it's for your principal residence and you don't need the mortgage or financing, then it's it's a benefit to just avoid that cost, because it can, over the course of 8 to 10 months, it can add up quite a bit. And I get a lot of questions about, well, is this coming off my purchase price, or this is being deducted from my purchase price? And it's not. It is truly basically like you're renting your own place, basically.
Yeah.
And so yeah, it can add up. So if you're able to avoid that, then it's definitely beneficial. But at least most time the occupancy fees that I see for the investment condos are less than market rate rent. So usually rent would cover even your interest portion of the occupancy fees. It would cover that amount. So you would, again, that's why it's important to make sure you get that consent from the builder to rent it out during occupancy. I do see a lot of Toronto builders offer rental programs, right out of the sales office or right directly with the builders, that they'll basically say, look, if you want to rent it out, we'll help you find people, we'll vet them, we'll do credit checks, which is also a bonus, because then you're not having to, find those tenants for yourself.
Yeah, exactly. No, great content, Chris. So kind of moving forward, so this question comes up a lot, I'm sure, no doubt for you as well, when people are, looking at pre-construction, and they may have not bought pre-construction before, they're maybe not familiar with using a real estate lawyer. What's the typical cost? So if you're going to use a real estate lawyer to review a pre-construction agreement, what does that whole kind of like life cycle look like, for you?
For sure. I can't totally speak for everybody. I think the way our office does it is we build the review, or the cost of reviewing the agreement is built into our overall legal account. So generally what you're looking at is, for example, I guess the one part, if it's just a review of the agreement, And there's no obligation then to close with us. It's $200 plus HST for the review of an agreement and dealing with any kind of amendments or discussions with you about the contract during the 10-day cooling off period. The second component would be there's an occupancy closing, which generally has a closing as a fee of around $250. And that's just the payment at the time of occupancy, because again, you're not getting your mortgage. And then you're looking at your kind of final closing costs for the actual closing. You're usually looking at a legal fee of, for most condos, there's a legal fee of about $800. Now, about $800, I should have qualified this, that $800 includes the $200 already for the review of the agreement. If you end up closing with us, we don't charge you upfront usually for the review of the agreement. We just say, we'll review the agreement, and then whenever the closing occurs, you would pay the $800 on the final closing, which would include, that's assuming you're getting a mortgage or financing as well. And then you're looking at your typical closing cost of registration costs, which to register the deed and register the mortgage is combined $153 right now. I will qualify that the ministry pretty much every year increases those costs by a couple of dollars. You have your typical search fees and disbursements, which are things like, title searches, courier charges, searches for, they call them execution searches to make sure there's no creditors that have any claims against you. On a new build, those are generally a lot less than a resale. That's typically around $200. And then you'll also have something called a title insurance premium, which is a one-time fee. Title insurance protects you and your lender typically against a variety of matters, but the main one is protecting against, if the builder hasn't paid off any of their contractors or subcontractors, so it's protecting you from construction liens, identity fraud, or title fraud, they call it, which is someone trying to put, fraudulent lines of credit or mortgages against your property after closing. That with condos is variable according to your purchase price, but on condos below $450,000, it's a $243 charge. So it's not a massive charge. So usually, if a condo you're buying around the $500,000 mark, you're looking at everything included, including the review of the agreement, the occupancy, the closing, your mortgage, anything else that really comes up. Help with. We always throw in if you are buying as an investment and you need to apply for that HST rebate after the closing. I prepare the application for you and help you send that off to the CRA. So you're looking at, for a condo of about $500,000, you're looking at about, it's $1,800, which would be kind of everything in there. Your review of your agreement, your occupancy, your closing is kind of all wrapped up in that $1,800. So, and again, I guess I should have mentioned again, it includes help with getting that, if it's an investment, that HST rebate back. So, and I don't think I mentioned this earlier, and I guess this is one of your follow-up questions is when you're buying for an investment, what's the HST that's applicable or payable on the transaction? So as I kind of mentioned before, HST is included in the purchase price that the builder will present to you. But again, it's assuming that you can assign this HST rebate back to the builder on closing, which you can only do if it's for your principal residence or an immediate family members. Now, the one thing that I should have mentioned too, that this has come up with us recently, is the definition of immediate family members is only limited to, like, brother, sister, mother, father. Doesn't include uncle, aunts, cousins. And I've had that, brothers and sisters, it does include. There is the rare case, and I won't use any names, but I have a client who purchased a pre-construction about 3 years ago in Toronto. At the time, I guess there was like a VIP or a pre-sale event, which people were able to go down and kind of pick the better units. He wasn't able to attend, so he sent a friend of his down who was told by the sales office, don't worry about it, your friend can sign the agreement and then we'll just take his name off and put it into your name. Well, he made the mistake of not having it reviewed during the 10-day cooling off period. It's been 3 years now. He's come to us for the getting ready for the occupancy closing, and mentions that he wants to have his friend taken off the agreement. We've sent that request to the builder's lawyer. They've come back and said no. Initially, they said no. Now they've come back and said, okay, we'll allow them to add my client to the agreement and remove his friend, but they want to charge him, I think it's administration fee of $5,000, which is, strictly speaking, it's allowed, at least in this contract, that they're allowed to do that. But he's run into an issue because even if he closes the property with his friend and it's for my client's principal residence, because his friend is not living there as his principal residence, and because his friend is not a immediate family member, even though it's his principal residence, he doesn't qualify for the HST rebate to assign it to the builder, because not all purchasers are living there as a principal residence, and they're not all immediate family members of one another. So he's stuck right now, and we're still working or trying to work with the builder's lawyer, but he potentially is going to have to pay that extra $24,000 on closing, and then apply for it back from the CRA, which, one, we're not sure that he has the extra funds to do that, and two, you also worry that does the CRA, and if anyone's ever dealt with the CRA, they know that they're not the easiest people to deal with. Sometimes you get someone who, decides to rule on your case for whatever reason, not against what kind of the normal practice is. And then you have an issue of arguing with the CRA to get that money back. So that's kind of just an example of why, when you sign those agreements, your kind of first thought should be get it to your lawyer, whoever they are, as soon as possible, to have them look it over, and they should be asking you all these questions at the time of what your intention is, and helping you through these things at the time, because while it can be fixed sometimes after the fact, the builders are getting a lot less, I think the word is, or they're a lot less willing to help out after the fact, because on their end of things, they're having issues as well, of where people have claimed that they're living in the property as their principal residence, don't end up moving in, and then the builder is not getting their HST rebate refunded to them, and then the builders now is having to usually just accept that loss, because the cost of lawsuits is probably outweighs it. So it's just really important that you sit down with the lawyer during that 10-day period, and kind of go through all these options with them and scenarios with them. And while things can change over the course of a couple of years, because if you ever bought a pre-construction, they usually take at least 2 or 3 years to actually get built. You want to make sure that you at least you've informed yourself of what your options are and what could potentially happen if, and we have this quite a bit, where a young couple purchases their first condo pre-construction thinking that it's going to be their first home, and then over the course of 2 or 3 years, life changes, and they get a job in another city, they have a child, they need a bigger place, and then their intention went from having it be a principal residence to having it be an investment. If you're not aware of all the kind of consequences or pitfalls of that, it can be a big shock to you, when you're coming up for the closing.
Yeah, it's a great point, Chris, and especially, like you said, especially people who haven't bought pre-construction before, the amount of things that you need to know, the typical person just doesn't know what's involved. And, coming back to, your point regarding intent, that's a major one that you and I both see, right? With regards to, I always tell people, and similar to you, be honest up front. Like, what is your true intention? What are you trying to accomplish? Are you going to live in this, or are you trying to buy this for investment? And I think that, we've encountered situations where, when people are very honest with their intentions, then usually you don't get into any trouble. But if you're trying to kind of, beat the system and, manipulate things to your point, CRA will come and find you. Right?
Well, exactly. And you see that quite a bit. I think there was actually a recent article in the Toronto, I believe it was Toronto Star, of that kind of very situation. Or not exactly that situation, but it was, and I, off the top of my head, I can't remember the name of the article, but it was a case of which basically went to intent, and the one thing you see quite a bit that you have issues with is how do you prove intent? The intent part of it is directly from the Income Tax Act, and the issue with that is, 3 years ago, if you bought the property for your principal resident, that was your intention. How do you prove that 3 years later? Or how do you prove that if if you've changed your mind, how do you prove that? And the recent case that was in the Toronto Star was basically what happened was, I think it was two brothers purchased a property, a pre-construction property. Over the course of years before it was finished, their circumstances changed. One of the brothers decided not to move into it. I think they either rented it or flipped it. And the CRA came back and said, well, that's an investment property now. You didn't qualify for the rebate. You should have paid it. Now, I think in this case, the gentleman, I think he spent about 6 years in court fighting the CRA. And I think he won because he was able to show that it was his primary intention at the time that he purchased. And, his life circumstances changed. I think he had children, and he had, I think, a sick mother that he had to help. And so the purchase of the condo unit just wasn't feasible for him anymore. But again, it took him 6 years to prove that. I don't even know what the legal fees would have been on that, but that would have been a very expensive legal bill. And so, as you were saying, Neil, before, I get this question a lot, as I get a lot of people say, well, I have a friend that did this and got away with it. And, this person never got audited, and this person did this and changed their mind and didn't get in trouble. And that's true. The CRA is not staffed with the amount of people to catch everybody. But I have had clients that have been caught, and the repercussions are just not worth it. It's not worth having the CRA audit you and chase you for this money. Again, the only way you ever really lose this HST rebate is if you flip the property after closing, which means that you declare it as a rental, pay the HST rebate to the builder on the final closing, but then you sell that property in the first year after closing. For people that do that, then you're not entitled to ever receive the rebate back. So that's the only way you really lose out on it. If you buy the property, rent it out for a year, and get your rebate back, you don't have any worries about it. It's only people that are doing it for flippers. And I see lots of people get away with it, who they don't get caught. But it's the ones that do get caught, the CRA is very, very strict and very non-forgiving. And even people who maybe have the innocent intentions and aren't doing it to be malicious, where they, again, I have another example of a client who purchased the property pre-construction condo with the intention that her son was going to move into the property after university and live there as his principal residence. Condos take 3 or 4 years to build. During that time, she herself went and bought a detached home pre-construction as well. It was her intention to move in this as a principal residence. So strictly speaking, she should have been able to qualify for the rebate on both transactions, because her son, which is an immediate family member, was going to live in the condo, and she was buying the house to live in as her principal residence. Well, before the condo was or just when the condo was finished closing, her son got a job, I think, out of province, decided that he no longer wanted to live there, obviously. And so when the property closed, or the condo closed, she left it vacant for about 6 months and then sold it, or listed it for sale. And during that time, her detached pre-construction home closed as well. So about a year, I think it was about a year after closing, the CRA, is I guess reviewing all the transactions, and they find that she sold this condo unit without having it ever been lived in by her son. But she still claimed the rebate because it was her initial intention for her son to live there. And strictly speaking, she should have been okay. But the CRA didn't see it that way. And, and they came back to her and forced her to pay that, I think it was about $25,000 back. And in her situation, well, I think she was being honest. And the problem with her is that she didn't have any evidence to back up her intention. She just had her word. And, while in that scenario, any kind of evidence would have been probably very difficult to have, but she didn't have anything. And the CRA, unfortunately, like I said earlier, is very difficult to deal with. And they're unlike any normal court of law where you're innocent until proven guilty. If the CRA thinks you're guilty, then you have to prove to them that you're innocent. Yeah. And well, I don't do litigation. I know lots of tax litigation lawyers, and they're definitely not cheap. And so if you're in tax litigation, you're going to pay. And while you might prevail in the end, your legal fees are more than likely going to come very close to what your actual penalty is that you have to pay.
Yeah, it's a great point, Chris. And, coming back to what you're saying with this particular lady, although you mentioned, she had honest intentions, right? Which,
right,
people do. Some people have, calculated intentions. Some people have honest intentions. But I think to your point, coming back to what you're talking about is, maybe having that proper guidance, at the time of purchase too would, potentially help, navigate different scenarios, right? Which is really helpful. And that's, how like you come into play with kind of, advising people, okay, if you're considering buying another property while you bought a pre-construction property, here are things that, you need to kind of consider so you can hopefully potentially, avoid those scenarios.
For sure. Yeah.
Yeah. So question for you. So with regards to, pre-construction, I know, we're probably coming to an end with this probably final question, but, in your mind, what do you see as maybe, one or two of the biggest, pros and cons of pre-construction investing? Because, as we know with the market in the Greater Toronto Area, the Toronto market, so many people are getting into pre-construction. In your mind, with your experience and from what do you see as the biggest plus sides and then the biggest negatives for pre-construction?
Yeah, well, I think the biggest plus is and with the market the way it's been in the GTA over the last 10 to 15 years, the biggest plus is the unit that you're buying. And just for example, in 2019, by the time it's completed in 3-4 years, the fair market value of that property has already increased. And so you're buying for basically at, when you come to the final closing, you're basically buying, let's for example, say in 2021, but you're buying at 2019 prices. And so your value of your property has already increased. Now, I guess that's all subject to market changes, but, in the last 10 years, that generally has been the case. And so it's just from that point of view, it's a great investment opportunity. Even for people who are buying for their principal residence, I think there's many cases you see of articles in the paper, Toronto Star, Globe and Mail, of people who, and this seems to happen more in Toronto than say outside of Toronto, but you see people who have put down deposits on pre-construction condos, and then 3 years later, the condo either, is not, the builder's not able to get financing, or something falls through. They get their deposits back, but that's not very helpful because the prices have gone up, 10% since then. And, so that's actually, I guess that'd be a downside of it, is you don't see too many developments that don't move forward. But a downside is that, and usually this affects people that are buying for principal residence. That 3 years, your money doesn't really gain. The builders pay you a tiny small amount of interest, if anything. So your money, you're not gaining any money on your investment. So if that ever happened, you basically would see you would get your deposit back, but in all likely, or in many cases, you would be kind of priced out of the market. And if anyone's, like I said, has read the Toronto Star or Globe and Mail, there's been recently articles about these projects. You are, you're kind of left, with your deposit back, but no house. And as I'm sure every first-time home buyer understands, GTA in Toronto is not an easy place to get into the market. So that would be a drawback. But again, that's not happening in many cases. So I think, again, the positive I would stress is, it's for investment purposes especially, but even in principal residence, if you can be patient and wait for the condo to be finished, you're almost all cases you're looking at right off the bat an increase in value. I think personally, for resale value, it's a lot easier to sell a condo that's 3, 4, or 5 years old rather than trying to sell one that is 30, 40 years old. Anyone that's owned a condo before, we haven't really even touched on this, and this is probably for another day, but is your condo fees. You'll see that condo fees kind of steadily over the years increase because there's just more maintenance, more upkeep, cost of utilities, repairs, all that kind of thing generally kind of increases, as the years go by. So your condo fees increases. So generally, that's why you see an older building will have a lot higher fees than a brand new building. So I think just for resale value, I think it's a lot easier to sell a newer condo than it is for you to sell a 30 or 40-year-old condo. The main drawbacks, I think we've gone over them, is really of the pre-construction is not, is not knowing that there's closing adjustments that generally most builders don't have them capped or don't have fixed costs to them, so they're open-ended. You see these. The biggest one is, in most contracts you see, is the builder will include all kind of building permits and development charges in the purchase price, but as of a certain date. So they'll say, as of August 2019, we're going to include all your development charges. But if the building doesn't get built for 3 years and development charges have increased over that 3 years, then they're allowed to charge you for those extra 3 years. I've seen cases and especially with the amount of growth in GTA, I've seen those development charges increase be $20,000, $30,000, which is a huge shock when you get that, you get that bill 30 days before the closing. So I think from I guess that what I would say, what I try to tell people and even family members who have bought these pre-constructions is you have to go in fully aware of what you're getting yourself into. We haven't touched on many things of the fact that, the builders generally have the ability to extend the closings 2 or 3 times over the course of 2 or 3 years. So you're not having you're not having the knowledge that that your closing is going to be this day, a specific date. It could get pushed because of delays in construction or financing or whatever. So I think it's the biggest thing is that people going in not being fully informed of what their options are and of what can happen, is I think is the biggest drawback to pre-construction. But if you go in, talk to your lawyer, someone like you, Neil, who I know we're out in Oakville. I find here that there is no the people that are dealing with the sales office actually are paid by the builder or employees of the builder. And so I think you don't get the best service from them because they have an incentive, obviously, to get you to sign on the dotted line. So people who, third-party agents who obviously are getting paid a commission, but who aren't employees of the builder, I think that's very helpful. And I think your biggest thing is just make sure you get that knowledge and you get fully informed, I guess is the easiest way to describe it. Because I think from an investment or a principal residence purpose or point of view, there's lots of money to be made in the GTA with the pre-construction condos.
Yeah, and Chris, all great points. And what we're gonna do now is for anybody who has questions, with regards to pre-construction, or even questions with regards to closing their resale transactions. What we're going to do is in the podcast we'll link your contact info, if that's okay with you,
For sure.
within the podcast. So we'll put maybe email and office phone number if that works for you.
Yeah, sure.
That's awesome. And then that way people can kind of connect in with you. Obviously, you're a wealth of knowledge, and when it comes down to closing real estate transactions, I've used you in the past, my family has, and clients. So I feel really comfortable with you and based on all of your knowledge. So what we'll do is let's do that. Let's end it there. But to your point, I think there's definite opportunity to even do another podcast touching on things that we haven't even touched on, and we're almost an hour in now. So if it's okay with you, then what we'll do is we'll cut it here, and then we'll put your contact info above and below, and then people can reach out to you and connect in with you with any questions, or if they have to close a transaction.
For sure. Yeah. And I think, it's our kind of office policy always is that the first initial consultation is free. So, questions, emails, I don't mind doing the initial ones for, no charge up front or anything like that. Usually if I have the time, I don't mind answering any questions. Even if you're not going to end up using us for closing, I can maybe point you in the right direction. So yeah, definitely feel free to reach out.
Okay, that's amazing, Chris. Thank you so much for your time, and thank you for everybody for watching. And we'll cut it here. Thanks again, Chris.
Great. Thanks, Neil, for having me.
Okay, no problem. Bye-bye.
Bye.